Jeffrey, you had talked about the discrepancies between this case and Rittenhouse and how you had said if you're black, you need to show that the victim had a weapon. Well, here's what I'm going to say. Couldn't the same thing have been said for the Rittenhouse case? Because there, one victim had struck Rittenhouse with a skateboard, another had a gun, another had previously carried a chain, was seen on tape running towards Rittenhouse, chasing him, threw a bag at him. Here, there's no evidence that Cleereman actually was running towards the defendant, that he lunged at the defendant, or that he was carrying a knife. There is a discrepancy there.
Well, I see what you're saying, but what I'll tell you is this. One of the victims in the Rittenhouse case, we don't know anything about what happened during the circumstances that he was shot. And in another, there was a discrepancy between was that weapon in his hand versus was it tucked in his waistband? And then a skateboard is now a deadly weapon. Is that what we're going to when it's Kyle Rittenhouse's life in danger? Versus in this case, where the defense felt that they had to put that knife in the hand. They couldn't just say that he could defend himself from this large man coming at him with a staircase that he could have been pushed down right behind his back. They couldn't just say that the racial epithets that were being spewed at him could lead to a beating so bad that it could lead to grievous bodily injury, which qualifies for self-defense with deadly force in the state of Wisconsin. They had to put a weapon in his hand. And the reason they had to put a weapon in his hand is because of race. It absolutely matters. If you don't think it matters, look at the judge's reaction to the screaming prosecutor's closing versus the judge's reaction to the raised voice of the black lawyer in his courtroom. Look at the way the judge talked to him throughout the trial. It absolutely matters in those courthouses in that state. It matters in a lot of courthouses throughout our country. And if anyone thinks that race didn't play a part in how they had to defend this case and how they were treated by this judge, you're wrong.
So I'm glad to have you here, Jeffrey, to talk about this. Just so I confirm, do you think that the attorneys, that the defense, the Edgecomb, could get a successful appeal based on the judge's actions in that courtroom? Do you agree that he was entirely unfair to the defense? And what specifically did he do wrong?
He wasn't just unfair, he was unprofessional, which is also an issue. He was screaming at them. He was ruling against things without hearing argument, okay? So we always hear about when things are going to get overturned on appeal, you have to meet these high burdens. And one of them that you typically have to meet is arbitrary and capricious. And arbitrary and capricious, when you hear an appeals court return something because of what a judge did, it's typically because the judge didn't allow the attorney to even make a record. And so they can't rule on something based on legal reasoning because they don't know what the judge is doing other than telling the attorney to shut up. And we basically saw that over and over and over again in the pretrial motions of this case. So absolutely, I think they have good grounds for appeal. But they also elect judges in Wisconsin. So that's a political position, which can make their appeal courts a little bit differently.
Yeah, the thing that I really had a problem with was his kind of so there was an objection, he not only just had sustained or overruled, kind of added extra commentary or was really emphatic with it as well. I didn't think the jury needed to see that. Jeffrey, before we go to a break, and Janine, stand by, we're going to get some more questions. I just want to ask you, Jeffrey, do you think the jury got it wrong here? Do you think that the defendant should have been acquitted?
I do. I think that based on what we saw here, I think there was reasonable doubt in this case. I really, really do. I think that when a defendant is telling a plausible story that is backed up by the physical evidence of the case, I do think that there should be a reasonable doubt for those jury. And I do think that they got this wrong. I bought what he was selling. I really did.
Okay. Jeffrey, Janine, there's a lot to talk about here. We're going to take a break. When we come back, we're going to focus a little bit more on this Edgecomb verdict. Stay with us.